Good morning, everyone, and welcome to today's Regulatory Transparency Project webinar titled Confronting the Questions, a discussion on the EPA's proposed revisions to endangerment finding. We're so glad that you're able to join us today. My name is Libby Dickinson, and I'm the Assistant Director with the Federalist Society's Regulatory Transparency Project. As a reminder, all opinions expressed are those of the speakers and not of the Federalist Society. We're honored to be joined today by an excellent panel of legal experts. Our moderator today is Laura Stanley, an associate attorney with Gibson, Dunn, and Crutcher. You can find more about today's moderator and panelists at fedsoc.org. That is fedsoc.org. With that, I will hand things off to Laura.
Thanks so much, Libby. So like Libby said, my name is Laura Stanley, and I am so excited to join the Federal Society today to discuss EPA's plans to revise its 2009 endangerment finding. Under various sections of the Clean Air Act, EPA is required to regulate emissions that cause or contribute to air pollution which may reasonably be anticipated to endanger public health or welfare. It's the official statutory language. In 2006, the Supreme Court held in Massachusetts versus EPA that greenhouse gases are considered pollutants under the Clean Air Act, and it found that EPA had improperly denied a petition by states and environmental organizations to regulate vehicle greenhouse gas emissions. But before greenhouse gases from new motor vehicles can be subjected to regulation, Section 202A of the Clean Air Act still requires that EPA make a two-part finding. First, EPA must find that the air pollutant in question may reasonably be anticipated to endanger the public health and welfare. And second, EPA must find that the motor vehicle's emissions at issue cause or contribute to this air pollution. In 2009, then EPA Administrator Lee Zeldin signed two key findings that allowed EPA to take a step closer to regulating greenhouse gases from vehicles. The first finding was that concentrations of 6 greenhouse gases endanger the public health and welfare of current and future generations. The second finding was that the combined emissions of these greenhouse gases from new motor vehicles in the United States contribute to global climate change. So these two findings impose no direct regulations on automakers or other industries, but they served as the legal predicate for EPA's greenhouse gas emission standards for motor vehicles. And EPA has issued at least 3 other climate endangerment findings since 2009. For example, in October 2015, EPA made an endangerment finding pursuant to Section 111B of the Clean Air Act for electric utility generating units. Earlier this year in mid-March, EPA Administrator Lee Zeldin announced that the agency will be kicking off a formal reconsideration of the 2009 endangerment finding in collaboration with the Office of Management and Budget and other agencies. EPA also announced that it intends to reconsider its prior regulations that rely on that finding. So the planned revisions to EPA's endangerment finding is likely to be an enormous undertaking for the agency and has implications for many regulations that rely on that finding. And it is all but certain to face numerous legal challenges. So we are sure to have an interesting discussion today. So as far as the format goes, we will hear from our experts and then we'll take time to discuss questions. So as Libby mentioned, please use the Q&A function to submit your questions at any time and we will ask them at the end. So I'll begin by introducing all our panelists and then I will turn it over to them. So first we'll hear from Michael Buschbacher. Michael's a partner at Boyd & Gray, where he has a particular focus on environmental and energy matters. Before joining the firm, Michael served as the DOJ as counsel to the Assistant Attorney General for the Environment and Natural Resources Division. Prior to serving in the government, Michael was an associate in the DC office of Sidley Austin, and he also clerked on the Sixth Circuit and on the U.S. District Court for the Northern District of Indiana. After Michael, we will hear from Professor Jonathan Adler, who is a professor at Case Western Reserve University School of Law. And he's also the founding director of the Coleman Burke Center for Environmental Law. He's a contributing editor to the National Review Online and a regular contributor to the Volokh Conspiracy. He's edited or written 7 books, and his articles have appeared in publications ranging from the Harvard Environmental Law Review and Yale Journal on Regulation to the New York Times. Professor Adler has also clerked in the DC Circuit and worked at the Competitive Enterprise Institute. And come July, Professor Adler will be joining the faculty at William & Mary, so congratulations on your new position. William & Mary is very lucky to have you. And then finally, we'll hear from Dr. Rich Belzer. Since 2001, Rick has been an independent consultant in regulation, risk, economics, and information quality. He previously served as a visiting professor of public policy at Washington University in St. Louis, and he also served as an economist in the Office of Information Regulatory Affairs, which is housed in the Office of Management and Budget. He receives his PhD in public policy from Harvard University and his master's in public policy from the Kennedy School of Government, now the Harvard Kennedy School. And he served in leadership in many professional societies, including the Society for Risk Analysis and the Society for Benefit Cost Analysis. He also completed a 2-year term as a member of EPA's Science Advisory Board panel on economy-wide modeling. So we're very privileged to hear from such an experienced panel of experts, and I will go ahead and turn it over to Michael.
Well, thank you, Laura. It's an honor to be here with such great panelists. So since I'm first at bat, I'm going to expand a little on the background here to start off with before talking about why one might want to get rid of the endangerment finding, and then some of the pathways that EPA could use to get there, and some of the pitfalls that they'll have to avoid, and which are quite significant. And I say, one of the things that's important here is to just note that we're still very early on in the process. There's not a proposed rulemaking out yet. There's just the announcement that they're going to reconsider it. What Administrator Zeldin has called the holy grail of the climate religion. I think it actually should be like the pieces of the true cross, because it's scattered all over. It's not just it's a thing that you find in many different places. And important to note, just kind of at the outset, is that the endangerment finding is not about whether climate change endangers anybody. It's about particular source categories under the Clean Air Act and whether the contribution to pollution or the pollution that pollutants themselves cause are going to endanger human health and welfare. So the story really starts, as Laura pointed out, with Massachusetts versus EPA. So there's a 1999 petition for rulemaking that EPA rejects during the Bush administration and says, under Section 202A1, this isn't a pollutant. So that provision says that EPA shall regulate the emission of any air pollutant from new motor vehicles, which, and this is a crucial phrase, in the administrator's judgment, cause or contribute to air pollution, which may reasonably be anticipated to endanger public health or welfare. There are a couple other similar provisions, but that's the one that was at issue here. So EPA denied it, saying, it's not, GHGs aren't air pollutants, and even if they were, there's scientific uncertainty and the economic impacts of climate regulation justify not regulating. So this determination was litigated up to the Supreme Court, and the Supreme Court, in what some might FedSox circles maybe call kind of a Bostock-esque opinion, said that no, EPA was wrong. Section 202A's capacious definition easily covers greenhouse gases, and that these economic impacts are simply not part of, not valid reasons for declining to regulate. The court did say that uncertainty could have been a proper basis for not regulating, but said that EPA had not actually made that finding. There was a dissent from Justice Scalia, joined by Justices Thomas and Chief Justice Roberts. That's classic Scalia barn burner. He says that, if you take the majority's approach, EPA can regulate as air pollutants everything, quote, from frisbees to flatulence. It's interesting because, flatulence is methane largely, so that is a greenhouse gas. And one thing that's very different from the conservative today is that the dissenters said that the court should have upheld it using Chevron deference. So shortly after the decision, Obama comes into office, and again, as Laura mentioned, EPA says there are 6 well-mixed greenhouse gases that they, in their judgment, think do endanger human health and well-being. Carbon dioxide, methane, nitrous oxide, sulfur hexafluoride, HFCs, PFCs. So a bunch of different things. And relied on a lot of scientific evidence, including the IPCC, the UN Intergovernmental Panel on Climate Change. And then after that, they started regulating, and that's when you have the first rules for greenhouse gas emissions from new motor vehicles, I should say. And because fuel economy and greenhouse gas emissions are two sides of the same coin, fact, the way the government measures fuel economy is by seeing how much CO2 comes out of the tailpipe for a given unit of work. That rulemaking was taken jointly with the Department of Transportation, specifically the National Highway Traffic Safety Administration, or NHTSA. So since then, at least during Democratic administrations, there's been a whole number of rulemakings in several different areas, including airplanes, but also motor vehicles, that have regulated greenhouse gas emissions based on this initial 2009 finding. Typically, the agency said it's not reopening it, which was a clever litigation gambit on its part, because the question of was the endangerment finding right, or has it ever become right since then, has never actually been adjudicated by any court. The DC Circuit has punted on jurisdictional bases to a whole bunch of challenges over the years, including CEI, where Professor Adler used to work. And if you're like me and you've got to litigate climate issues in front of the DC Circuit, that probably won't come as too much of a surprise that they have been pretty hesitant to get into the merits and have focused on jurisdictional questions. So there are a number of arguments that the endangerment finding was wrong at the time it was made, and has not gotten right since then, that it underplays the uncertainty, that it doesn't have, that the scientific evidence it looked at wasn't sufficient to justify the outcome, or had sort of problems with it, or wasn't properly disclosed. And then also whether the marginal impact of new motor vehicles in the US is actually the kind of thing that can cause or contribute to global climate change significantly enough that it justifies being regulated under 202A. So there's also an argument, I'll just flag this up front, that Congress has somehow ratified the endangerment finding in subsequent legislation. They certainly kind of wanted to suggest that, but they didn't actually do that because they had to get those bills largely through reconciliation, which wouldn't have allowed them to modify 202A. So, they have kind of an atmospheric effect, but the notion that this has somehow been legislatively settled is not correct. One final key point on the way things played out following Massachusetts versus EPA is several years later, the court decided a case called AEP versus Connecticut, which said that the Clean Air Act displaces federal common law regarding transboundary emissions, and in that case, looking particularly at greenhouse gases. That is very important because since then, states have tried to use state common law and state legislation to go way further than the federal government has, to the point of, I think, the current slate of litigation and laws have an estimated cost to the energy industry, if they succeed, of $28 trillion. So a very big sort of thing that looms in the background here. So what are EPA's options? I think they've got two main things they can do. Option one is they can take a run at challenging the legal basis for the endangerment finding. I think there are two variants of this. One is to basically say Massachusetts versus EPA is wrong. One way they could do that would be by saying, look, Massachusetts versus EPA says that NHTSA and EPA can both administer their regulatory regimes without inconsistency, regulating the same thing using very different statutes. But subsequent experience has shown that that's wrong. So, for instance, under the Biden administration, the two agencies decoupled their rulemaking, so they did them separately. I like to think of that as kind of like that guy from Coldplay and Gwyneth Paltrow consciously decoupling. They consciously decoupled those rulemakings, and they're no longer consistent. They're not harmonized. And so that shows that, at least in these most recent rules, that Massachusetts's sort of factual basis about how this could work was questionable. Then, of course, there are the legal arguments that the court rejected there. The big change here is now all the 5 justices who were on the court in the majority are gone, and you've still got Justice Thomas and the Chief, and you've got some folks who have joined the court since who probably would not have joined the majority had they been around when that case was initially decided. Endangerment, they could also look at narrowing their interpretation of endangerment in addition to looking at the definition of air pollution. Of course, statutory stare decisis is hard to overcome. And there are a number of kind of practical difficulties. There's no way the DC Circuit can rule in their favor. And if you have a panel that doesn't want that case to go further, they can, there are always opportunities to create vehicle problems to keep away easier from the Supreme Court. And I'm not candidly sure that the Supreme Court would be interested in taking this issue up again. So those are some headwinds that they face there. Slightly different option is to kind of address endangerment within repeals of other rules. And there's a better argument that you can make that the manner in which the endangerment finding has been used to regulate it violates the major question doctrine, which says that if you have an agency adopting a novel interpretation that is going to have serious economic or political consequences, you need a clear statement. And that's West Virginia versus EPA, which of course is a climate EPA regulation case, though not about mobile sources, but about stationary sources. So this doesn't pull the Band-Aid off all the way, but it may be, has a higher chance of success ultimately. And then on the factual side, EPA can challenge the science across the board, which is an enormous undertaking because you have not only the initial 2009 determination, but all these other ones. And that's the bulk of climate science. There, of course, are people who disagree with that, who have smart arguments about why they think that climate change is why there's greater uncertainty, or why the additional marginal impact of more carbon in the atmosphere is not going to change anything or endanger anybody. But that's not the majority view, and explaining why the agency has been wrong for well over a decade is going to be a tough thing to do, because you've got arbitrary and capricious review that is going to require, because it's a change in position under FCC versus Fox, the court's going to demand giving reasons for why the new approach is better. Of course, the reason why you might want to do this is the cost of climate regulation is extremely high. And I think this is the main reason why they want to take it on. The Biden tailpipe regs for cars, the EPA estimated under the Biden administration, we're going to have something like $1.6 trillion in costs. And that's just one rule, and there are many others. So you're talking truly enormous impacts on American industry, and things like driving the electrification of the motor vehicle market. The new rules require about 62% electrification in just a few years. That kind of shift is at least as significant as the shift that the court in West Virginia said went way too far. On the factual side of things, there's a narrower approach too that I'll just flag real quickly before wrapping up. And that is that the statute does say in the administrator's judgment, and it does tie it to emissions from new motor vehicles, not just motor vehicles, but only new ones. The marginal impact on that to climate, you can make I think a pretty good argument that where we are going globally is not going to be affected by our regulation of that one way or the other. So there's no marginal impact. If you could show that, then that would provide a different, slightly narrower basis for revisiting endangerment. The final sort of problem I'll flag is that if you do undo endangerment, that does potentially reopen the question of whether the Clean Air Act displaces federal common law. And one of the arguments that has been made in all of these climate suits is that the Clean Air Act also displaces state common law and state authority to regulate greenhouse gas emissions. So if the Clean Air Act doesn't stretch that far, or at least this part of the Clean Air Act doesn't, and there are other parts that do, then there's an argument that AEP should also be undone, and that you'd have federal common law come back into play, which would open up a new avenue for challenging, for states and others to challenge emissions from the energy sector. Not sure that federal common law would be worse in the final analysis than state common law, but that is sort of a downstream question about whether under the current system we have preemption of all state climate regulation for emissions. So looking very much to the debate as we get going further, but while there are some significant headwinds, rereading Massachusetts just made me super angry all over again, because it really is kind of a ridiculous decision. And There are better ways of doing this, and it should be in Congress's court, not with the agencies and not with the courts to set our global climate policy.
All right, thank you so much, Michael. So as a reminder, you can drop your questions into the Q&A function. I've seen some coming into the chat, so we'll get to those at the end as well. For now, I'm going to turn it over to Professor Adler.
Well, great. Thank you. It's a pleasure to be here to talk about endangerment finding, something that some of us have been thinking about and wrestling with now for close to 2 decades. I agree with a lot of what Michael said. I'm going to highlight a couple things where I view the history a little bit differently, and I want to say a little bit about why I have characterized what EPA Administrator Zeldin has asked the agency to do as a fool's errand, as something that will waste resources, tie up agency personnel on something that will not succeed, will not accomplish what their purpose is. Let me just, as an initial matter, note what I am not claiming. I am not claiming Massachusetts versus EPA was correctly decided. I submitted an amicus brief with the Cato Institute back in that litigation, arguing that the Clean Air Act should not be interpreted to apply to greenhouse gases, and I still believe that would have been the better interpretation of the statute, but it is not the one that the Supreme Court adopted, and not the one that the Supreme Court has, at this point, subsequently and repeatedly reaffirmed. Indeed, Chief Justice Roberts, at oral argument in one case, said quite explicitly, we don't do that about the question of revisiting the statutory holding to Massachusetts versus EPA. The question before us is not whether the Clean Air Act as a policy matter is a good way to deal with climate change. I am on record for years saying it is a fundamentally unserious, destructive, and wasteful way of trying to deal with climate change. It is a poor set of tools to try and deal with the accumulation of greenhouse gases in the atmosphere, a set of tools that can impose substantial costs and will do nothing meaningful to reduce the accumulation of greenhouse gases in the atmosphere. So for those on this program that are particularly concerned about climate change, trying to maintain the use of the Clean Air Act for this purpose is like looking for love in all the wrong places. This is a waste of time and resources. It is not what someone serious about the climate challenge should be focused on. Thirdly, this is also not a question about whether or not reducing atmospheric concentrations of greenhouse gases or emissions of greenhouse gases is net welfare beneficial. I happen to think it could be. I know there are others who disagree, but that's also not the question that the EPA is confronted with. The question that the EPA is really confronted with is whether or not the findings that have been made with regard to Section 202 and then subsequently with some other provisions of the Clean Air Act that the emissions of greenhouse gases cause or contribute to air pollution that can be reasonably anticipated to threaten public health or welfare can or should be revisited. And as a lawyer, I think it's important, those of us that are lawyers, to focus on that is the legal question before the court. Michael noted some other questions about EPA's authority that I think are very interesting. I think as an analytical matter, though, we do want to recognize that EPA deciding to challenge the statutory interpretation in Massachusetts versus EPA is distinct from challenging or revisiting the conclusion about satisfying the endangerment finding under Section 202 and other provisions of the Act. Those are distinct questions with distinct implications. So just for example, if the EPA were to reject the Supreme Court's interpretation of the Clean Air Act in Massachusetts versus EPA, again, I'm not sure the court's willing to go there. I think the court's view is that statutory stare decisis. It was a decision that did not rely upon Chevron deference. The court, again, wrongly, in my view, said this is the clear meaning of the statute. That would obviously remove EPA's authority to regulate greenhouse gases under the Clean Air Act for any provision. It would, in effect, eliminate displacement of federal common law under AEP. It would also eliminate a preemption of California greenhouse gas vehicle emission standards, because undoing Massachusetts versus EPA would be saying these emissions are no longer subject to the Act, and in particular with regard to California standards, not subject to Title II of the Act, which is the basis for preemption of California standards. That's distinct from rolling back the endangerment finding, which in my view, and this is not a consensus view, would not disturb AEP and would likely not disturb preemption of California standards, because the endangerment finding is not about whether or not greenhouse gases are subject to regulation. It's rather whether or not the administrator can make the conclusion that triggers regulation. Right? These are one is a predicate to the other. Right? First is the question is, are these things like flatulence and Justice Scalia's famous formulation, things the EPA could regulate? The endangerment finding is then about whether or not, given that it can, must it or should it, given the language of the statute. So that's just some brief kind of setting the stage of how we should be thinking about this question. In terms of thinking about what the actual endangerment finding itself, I think it's important for us to remember what the statute says and to think carefully about what the statute says. So we're going to start with Section 202, and there is similar language elsewhere in the Act. In a minute, I'll talk about how there are some places where this language varies a little bit, and that might give the EPA an opportunity to do kind of mini endangerment, either withdrawals or preclusions. But let's start with Section 202 because that was the initial primary endangerment finding. And there, the administrator is required, right, shall by regulation prescribe standards when the administrator concludes in his judgment that the emissions of the pollutant cause or contribute to air pollution which may reasonably be anticipated to endanger public health or welfare. And I think that language is important for a bunch of reasons. One, it is only about, do these emissions cause or contribute, so they play a role and not even contribute to any meaningful magnitude. There are other provisions of the Clean Air Act. Section 111 is one, I believe Section 213 with regard to non-road vehicles is one, where the statute says contribute significantly. Those provisions are distinct. Here it's just contribute, and because it says contribute significantly in some parts of the statute, but not here, that means we are not asking for some judgment about the degree of contribution. It's just a contribution. And that contribution may reasonably be anticipated. So we're not asking for proof. We're not asking beyond a reasonable doubt. We're not asking preponderance of evidence. We're not asking, is this absolutely certain? Can it be anticipated that what's being contributed to will endanger public health or welfare? And again, endanger doesn't mean net welfare reducing, does not mean on net harmful. It's just, can you reasonably anticipate? Is it reasonable to think, yeah, this bad thing could happen? And then public health and welfare under the statute, welfare in particular, are defined exceedingly broadly to include just about everything. This is, in the way we think about the way environmental statutes are written, incredibly precautionary language. Now, we may think, I've certainly written, that precautionary approaches to risk regulation are often a really bad idea, that loading the dice in favor of regulation tends to be bad for human welfare, tends to be bad for lots of things. But I wasn't asked to write this statute. Congress, when drafting this language, chose to use very precautionary language that does not ask the administrator to decide whether or not regulating the substance is a good idea, does not ask the administrator to decide whether regulating the substance it will on net be a good or bad thing. And the reason I spend this time stressing these points is because to undo the endangerment finding, it's not enough to say regulating greenhouse gases is really expensive and bad and does more harm than good, or regulating greenhouse gases is worse than focusing on climate adaptation, or using the Clean Air Act is going to be ineffective, or regulating greenhouse gases won't actually solve the problem. One can believe all of those things. None of them are responsive to what the EPA is required to focus on. And as Massachusetts versus EPA pointed out, in the one part of the decision that I think is correct, an agency like the EPA is required to first and foremost focus on the criteria and the considerations that Congress told it to focus on. And so in order for the EPA to undo the endangerment finding, what the EPA basically has to be able to say is that it is unreasonable to anticipate that greenhouse gases accumulating in the atmosphere can endanger public health or welfare. And the reality is that's not something that I think the EPA is capable of saying. It's not something the EPA is capable of saying without literally undoing and rejecting virtually everything the agency has said for the past 35 years, including the things it said when it denied the petition filed by Massachusetts that led to the Massachusetts versus EPA decision. Further, it's also inconsistent with the arguments made by most what we might call lukewarmers or climate skeptics, right? That is to say, if you look carefully at the work of people like Bjorn Lomborg or Steve Koonin and so on, their arguments tend to be climate change produces some bad effects, but look, there are all these other things that are bigger problems in the world, and the resources that will be required to address climate change could be better spent dealing with these other problems. Again, you may agree with that. That is not the question that the Clean Air Act asks the EPA to consider. And the various folks that are climate skeptics out there don't claim that there's zero anticipated effect on weather, zero anticipated effect on temperature extremes, zero anticipated effect on sea level rise. They just say not a disaster. But the statute doesn't ask the EPA whether it's going to be a disaster. It asks, can the EPA reasonably anticipate these negative effects on public health and welfare defined very broadly? So I think just as a legal matter, this language in this statute puts the EPA in a decision. And when back in 2012, in the litigation, when the endangerment finding was challenged, the DC Circuit did say that the endangerment finding was not arbitrary and capricious. Even en banc, at most one or two judges on the DC Circuit half-heartedly raised questions about that finding. I think for the reasons we see there, it's something that would be incredibly difficult for the EPA to undo given existing standards of review. Let me just say one last point, because I've gone on a bit. We tend to talk as if the endangerment finding under Section 202 is necessarily the same for all purposes of the Act. And that's not quite true. There is very similar language in Section 108, which raises some different questions, which would relate to whether or not greenhouse gases could be considered criteria air pollutants for purposes of NAC standards. I think for the reasons we saw in UARG, if the EPA tried to do that, if a lower court tried to force EPA to do that, that door would be closed. There is similar language in Section 183 for tank vessel standards, Section 232 for aircraft standards. What's interesting is that in the provisions that relate to non-road vehicles in Section 213 and the provisions that relate to source-specific stationary sources under Section 111, like was at issue in the Clean Power Plan, the language varies. And that the question that the EPA is supposed to consider is whether the emissions from the source category contribute significantly. And I do think that does raise some different questions, not really about undoing the endangerment finding under Section 202, but do I think create possibilities for the EPA, particularly for smaller categories of emissions. So, once you get past power plants and maybe one or two other source categories, the percentage of US emissions, let alone global emissions, that a particular category is responsible to starts to become very, very small. I think there is room for the EPA to perhaps say, for example, maybe, cement kilns don't contribute significantly under Section 111, or this particular subcategory of off-road vehicle engines don't contribute significantly. I think there's room there under those provisions because of the addition of that additional word. But for the endangerment finding broadly, for the idea that legally you could somehow undo the EPA's ability and indeed obligation to regulate greenhouse gases without unleashing federal common law litigation and California emission standard regulations, I just think legally that's too big a lift. And I think the resources that are going to be spent trying to do that are resources that could be better spent on other efforts that could produce tangible and long-lasting deregulatory results, which is something that I think many of us would like to see. So I've gone on a bit. I will stop there. Thank you.
All right, thank you so much, Professor Adler. So Again, please drop your questions into the Q&A function and we will get to them when we're done. And last, we will hear from Dr. Belzer. I'll turn it over to you.
Thank you. I just, as a point of departure, I want to say that my interest in this is on in the quality of the science that the EPA would rely upon, and then secondly, I'm interested in any way that the economics of the problem could be folded in. I don't see how that could happen with revisiting the endangerment finding. I will say that I don't believe that the endangerment finding was effectively challenged on matters of science quality, and the courts involved have been highly deferential to EPA's purported expertise on those matters. But if the science isn't challenged, then there's not much else that we can do given the broad language of the endangerment finding. I see three different ways that EPA, because that's what we're dealing with here, could reverse the endangerment finding, at least provide the basis for doing so. The first would be for them to say that the science as of 2009 was wrongly interpreted when it was relied upon in 2009. It could, alternative, number two, it could say that the 2009 science has proved to be wrong in the intervening 16 years. It's the extent to which there were predictions with regard to climate that were made in that literature and have proven to be incorrect. That provides another pathway. And then third, EPA could take a look at the 2025 science and say, well, the 2025 science makes a more complicated case, such that the conclusion reached in 2009 may have been premature. Fourth possibility is something else, but I don't know what that would be within EPA. I think that there are some significant practical barriers to EPA doing this. The first is that I don't see EPA staff ever being willing to write the documents that would be required, even if we stipulate that that everything I just said before about the science, it all falls apart. I don't see EPA doing that. I think that an infinite number of monkeys with an infinite number of work processes would produce that document sooner than the EPA staff. So then who can do this? Well, it's going to have to be Congress. And Congress doesn't really have a role in this. Their role came and went when they enacted the statute in the first place. What can be done? A normal bill to repeal it is not feasible to get out of the Senate. I presume that it's possible to get it out of the House. But the fourth option, the option that Congress could take, is a very high-risk tactic that we'll call it Congressional Review Act chicken. And that would be a situation where EPA does issue a new document. I would think that a Congressional Review Act chicken approach would be to issue a document that takes away all of the flexibility that EPA has thus far provided in its regulatory agenda, and maximizes the short-term pain, maximizes the costs that would be borne by American households. I want to put in a marker here. I think Michael was talking about costs on industry, and I think that's not an accurate portrayal of the way costs are borne. Costs are borne by households. They're not borne by firms. Firms pass them on. They pass them on to customers. They pass them on to stockholders. They pass them on to bondholders in some respect if they default. They pass them on to employees and to managers. They pass them on to suppliers. But unless they can export costs either to another nation that they don't operate in, or they export them to the future, shifting costs to the next generation, all costs are visited on households. And those costs of achieving something like net zero 2050, which is, arguably still the goal, the popular goal among the advocates of regulatory action. Those costs amount to, depending on the social cost of carbon and how inefficient the Clean Air Act proves to be when used as the tool for achieving these goals. If you look at a social cost of carbon of about $100 per metric ton, we're talking about we'll call it kind of an average across states of household level cost of 5 to 10% of median household income. That's a significant effect. If the costs are higher than that, the consulting firm McKinsey has in their kind of least efficient scenario social cost of carbon of $700 per metric ton, which I don't find astounding given the inefficiency of command and control regulation. But now we're talking about roughly half of median household income. And if households had to give up half of their income for this purpose, I think that the politics of climate change would be very, very different. And on top of that, if we wanted to be partisan about it, and I do so only not as a point of advocacy, but the point of being descriptive, one could do this in a manner that shifts a disproportionate share of these household costs onto households in blue states. And that certainly can be done. Now the question is what happens, and this would be teeing it up for Congress to using the Congressional Review Act to pass a joint resolution of disapproval, which President Trump clearly would sign, and that would set in motion in practice, there would be no way for EPA to do anything like this again. Congress would have to take action for this to be revived from the dead. That is an extremely risky approach. It has some significant prospective benefits if the approach were successful. The costs would be horrendous if it failed. But that's an option out there if they're serious about it. I don't think that a direct approach, a direct attack on the endangerment finding would work. However, like John, for different reasons, I just don't see EPA doing the work that would be necessary. If they produce a document, it would be so full of landmines that it would certainly lose in court. That's the end of what I have to say in prepared comments. I look forward to questions.
All right, thank you so much. So we have quite a few questions that I would like to get to, but first I wanted to see if Michael, if you wanted to very quickly respond to any of the questions.
So I think I disagree a little with Professor Adler about exactly what the question is. So I don't think the question is whether greenhouse gases endanger the public health or welfare. I think it's about whether the emissions from new motor vehicles cause or contribute. And by the way, I don't think to read the cause and contribute or contribute the way Professor Adler does, I think makes it redundant. I think contribute here has to mean like it's a precursor to a pollutant being formed. So that's like some stuff gets in the atmosphere and then it interacts with other stuff and then becomes something that's a pollutant. Because otherwise, I think it would be, because otherwise you'd just be reading cause and contribute as essentially meaning the same thing. Because no emission from anything in the United States is the sole cause of any kind of pollution in the atmosphere. So, and the question is like, at what point does something? I agree the significantly language in in Title I of the Clean Air Act is different. But at some point you have to say, well, is the contribution from this type of source actually causing or contributing to the endangerment? And I think it just means but for cause. And if it's not a but for cause, in other words, if the harm would have happened anyway, then I think there's plenty of space there in the act for the administrator to say, in my judgment, this doesn't. And that's an important word in the statute too. I think it takes you out of arbitrary and capricious land into abusive discretion land, at least to some extent. So the other thing I would point out is I think you're saying, Professor Adler, that AEP doesn't depend on the endangerment finding. I agree with that. But then you also said something about return to federal common law. I think that would only happen if you had a pretty serious limitation or overruling of Massachusetts versus EPA itself. But maybe I misunderstood you there. And last point on Rick's CRA idea, I think it's fantastic. I love that idea. I love the idea of if they lose on whatever they end up doing on the endangerment part of it, doing a direct final rule, send it over to Congress, and then Congress can CRA it, send it to the president. And then you have, the agency is prohibited from ever doing something substantially similar again. Untangling that would certainly be a little bit messy, but yeah. So those are my reactions. But I do think it's very important to just emphasize that it's not about greenhouse gases writ large. It's about the contribution from a specific set of sources, which are divvied up in different ways across the act.
Professor Adler, I'll give you a chance to respond quickly before we move to questions.
Yeah, so so first on Massachusetts versus AEP, I think we agree. So AEP and AEP is often misread, right? It's about displacement, not preemption. Those are two different things. AEP makes very clear that what causes displacement is the existence of a statute in the space, not regulation, not federal action that actually is addressing the problem. I think the opinion is very clear about that. I think the history of how displacement is different from preemption makes that very clear. So I think we agree. The only way EPA playing in this sandbox undoes the result of AEP is by getting the courts to reverse the statutory holding of Massachusetts versus EPA. Ending federal regulation in some other way of greenhouse gases in some other way would not matter because displacement is about whether or not Congress has entered the field, not about what policy choice Congress has made in that space or what policy choice an agency has made with that delegated authority. And I think that whether or not California vehicle emission standards for greenhouse gases are preempted probably follows in parallel. That's a slightly different question, but I think there as well, it's not clear to me that undoing the endangerment finding would mean that California's greenhouse gas emission standards for vehicles would not be preempted and not need to obtain waivers, because I think that under the statutory holding of Mass versus EPA, they would still be subject to that title even if EPA wasn't using that authority. On the contribute part, I think we do disagree in the sense that the way I understand cause or contribute, and especially thinking about the history of environmental regulation, is that whether we're talking the Clean Air Act, Clean Water Act, Congress knew that there were certain things that were in the environment naturally, and that human activities could cause the volumes or concentrations of those things to increase to a degree that would cause problems. And it also knew that there were things that generally weren't in the atmosphere, air naturally, or in the water naturally, that were only there as a result of human actions, and the cause or contribute language captures both. Now, it may well be that there are lots of things that we thought were in the pure, humans are the only cause of bucket that we have subsequently learned are more in the contribute bucket than we thought. But I believe that when you go back through that history, the scientific understandings, the cause or contribute language is trying to embrace them both. So to take one very easy example, think about nutrient loading in water bodies, right? So, because there's a common argument in the climate space, oh, CO2 is it's plant food. Well, yes, but that's irrelevant. All kinds of nutrients are plant food. They can also be pollutants for purposes of federal law. They can also cause environmental harm when they get reach levels beyond them. So the fact that something can be beneficial in some contexts or in some ways doesn't mean it can't be harmful in another way. And so I think the contribute language, especially when you have other parts of the statute that say contribute significantly, means that we're talking about, is this something that's identifiable and measurable? And certainly if we're talking about new motor vehicles, we are. And I think when you look at the statute, last point, I know I'm going on here. When you look at the statute and look at where contribute significantly is used versus where contribute is used, you actually do see a pattern. When you're talking about big contributors, large classifications, all new motor vehicles, all aircraft, the language is contribute. The assumption is we're talking about lots of stuff. When you're looking at provisions like Section 111 or Section 213, where you're looking at much smaller categories, right? Different categories of industrial facilities, different categories of non-road engines, of which there are lots of very small niche sorts of things, significantly is used because Congress didn't want the EPA to spend all this time chasing down little niches, little niche contributors. And so I think there's room there, but I think that just reinforces the idea that trying to say, oh, we can say no endangerment because the contribution isn't large enough, doesn't work for Section 202, doesn't work for Section 183, or it doesn't work for Section 232, might work for most applications of Section 111 and Section 213, again, because there's that different language.
Okay, I'm going to go ahead and jump to some questions. So how do you all think that EPA will frame the economic and cost considerations based on the statutory language, the existing case law? Can EPA consider costs when assessing endangerment?
I'm already on point on this saying no, and I will just note, in American Trucking, if you go back to that litigation, a very similar argument tried to be made there, and I was a lowly peon in that case, trying to argue that the EPA should be allowed to consider costs when setting national ambient air quality standards, because language about things like welfare and public health and so on necessarily assumes net welfare maximization or net maximization of the health. Not a single justice on the Supreme Court thought that was even a plausible argument under American Trucking. I would be very surprised if a parallel argument here, given the language of the endangerment provisions in the statute, could get anywhere. Costs are what you think about when you set the standards, when you decide what the regulations are, not in deciding whether or not something is contributing to endangering health or welfare.
Then let me just jump in and say that I would love to see an analysis of the extent to which the endangerment finding causes or contributes to morbidity and mortality in the United States.
All right. I'll jump to another question. So this administration has been relatively bullish about using rulemaking procedures such as interim final rules that do not provide for notice and comment prior to promulgation. Would EPA need to accept and respond to public comments on the endangerment finding prior to finalization?
Well, I mean, you can't stop them from issuing interim final rules before they do, but that would be a serious mistake. This is the sort of thing that is going to require public comment as I read the Clean Air Act. There is one sort of wrinkle that they could take advantage of, which is if you, in notice and comment, usually there's the sort of logical outgrowth doctrine, which says that you can't introduce something at the end that you didn't include at the beginning, especially in the Clean Air Act with data that you're basing your decision on. But Section 307 of the Clean Air Act also says that if there's something new in the final rule that wasn't in the proposal, then those who wish to challenge that can first have to petition the agency to address that issue, and only then, after the agency responds, can they sue. which allows for an infinite regress problem. This is something the DC Circuit, I think, has created, but it's an interesting option here where if you keep on moving the goalposts, you keep on forcing people to file new petitions, and you can delay judicial review if you're the agency on this. Justice Barrett seems to have a pretty broad view of this, but the majority of the Supreme Court last term in a case called Ohio versus EPA read that more narrowly, but that is an open question. But in terms of like, can you avoid notice and comment altogether? I think that would be a big mistake.
I agree with that. I mean, I would just add two little wrinkles. One, where the administration, I think, is on strongest ground in trying to do interim final rules in the environmental space are where there are either court decisions that suggest existing rules are problematic, or where the administration has a strong argument that the plain meaning of a statute does not, in fact, allow for the regulation that was issued. That's a high risk. There's some recent scholarship out suggesting that if the agency's claim is the statute doesn't allow this, that the imposition and enforcement of an unlawful rule should be good cause, right? Preventing people from being unlawfully regulated should be good cause, but you're only going to prevail if the court ultimately accepts your statutory interpretation. So in cases that hinge on statutory interpretation, there's an argument there. It's a high-risk strategy. It can be done. The other thing is that, under the Little Sisters opinion, you can certainly do an interim final rule, initiate notice and comment, and if you can get through the notice and comment process before a judicial review on that rule, you might essentially get away with it, especially if the rulemaking comments don't produce anything that requires the rule to be revised. Again, there are contexts where I think you could do that. I think, and I know Rick might have thoughts on this, I think the volume of things that you are opening the door to once you open this box make this a very bad candidate for trying to use interim final rulemaking, because you're not primarily trying to do a very narrow statutory argument. And then once you get into the underlying stuff that leads to endangerment, you're not talking about a small discrete amount of material, small discrete amount of comments to respond to. You're going to be drinking water from a fire hose, and so I think it's a bad candidate for using that technique that might well work in other contexts.
All right, I think we have time for maybe one more question. So Michael, you mentioned that the DC Circuit declined to review the finding on the merits due to jurisdictional issues and the initial endangerment finding. Do you expect that it would be similarly difficult for, the almost certain challenges to get past these jurisdictional bars? Happy to hear from anyone on this.
Well, I mean, that was a very strong argument in Massachusetts itself, which was, the first part of that opinion is about standing. This is where the special solicitude, every little tiny bit counts for purposes of standing. I think the Supreme Court I don't think they view any part of that standing decision as right anymore. I don't think they're going to overrule it outright, but I do think it's certainly not the direction they're heading. So I think with something that's about the same provision, I suspect one way or the other, we're going to have a different approach to standing if it comes to challenging this. And of course, if it's in a new rule, like a power plant rule or a rule about vehicles, then it's easy to challenge. You just say this, this hurts my business, or this, all the usual standing arguments that everyone makes when they go to court to challenge a rule that actually puts new, provisions in the CFR and requires people to change their behavior.
I mean, just jump in. I mean, the DC in the first Council for I always get the name wrong. Council for Sensible Regulation or Coalition for Responsible Regulation decision. The DC Circuit did say the endangerment finding was not arbitrary and capricious, so they did reach that. They rejected on standing grounds that the challenges to the timing and tailoring rule on a very bizarre theory of standing that the Supreme Court did not even think needed to be dignified in the UARG opinion. And I think the Supreme Court in, I'm going to get the name, Michael's going to know the name of this case better than I am, but in the case concerning standing challenging the California waiver right now, the court is going to make clear, I think, that when you can identify a clear economic impact of a regulation on your business or your industry, you have standing. And so I don't think there would be a problem challenging standing here. There might be other issues about, is the court going to narrow state standing? Is it going to narrow the sort of standing theories that are relied upon in other climate contexts? I'm inclined to agree with Michael that I think the court is going to try and cabin that part of Mass versus EPA without expressly overruling it. Kind of say, well, if you're on all fours, you're fine, but don't try using this elsewhere. But I think that'll have its greatest effects in ADA tester litigation and other sorts of contexts that are outside of the climate space.
Awesome. Well, thank you so much. I'm sure we could talk for another hour about diamond alternative energy and standing, but I think we are out of time. So thank you so much to our excellent panelists and to the Federal Society for hosting. Libby, I'll turn it back to you.
Great, thank you. What a fantastic discussion. Thank you so much, Laura, for moderating, and thank you again to our panel for joining us and for sharing your incredible insights today. For more content like this from the Regulatory Transparency Project here at the Federalist Society, discussing the regulatory state and the American way of life, please visit us at regproject.org. That is regproject.org. Thank you.